We are going to speak land ownership, and we'll speak with the marketing director of Daniels and Associates. And we are going to speak with Miss Daniel. Good morning and welcome.
Good morning. Well, good morning and thank you.
All right, so we need to hear in the studio.
And I think she's the managing director of the company.
All right. Okay, so we got that. Right. So let's talk about land ownership. All right. So just give us an overall view as to your portfolio and what we're speaking to land ownership, but just give us a broad perspective and we can zero in on how important it is to own land and what the benefits and so on.
Okay, so thank you very much. Yes, I am the managing director currently at D.L. Daniel and Associates, and as a firm, we are committed to the democratization of law, which is a bigger word to basically say having law understandable and accessible to the homes of the civil society. We found that law and legal education locally is not something that every person may necessarily understand. And just as Google has democratized information or Samsung democratized technology, we are seeking to democratize law and helping persons understand different aspects of law as it touches their lives. And as a firm, we have several aspects of civil legal information and education that we promote, primarily probate and property law. And this land ownership convention is no different. It's a 3-day convention. Yes, my name is Shaquilla Daniel. A 3-day convention focused on primarily probate and property and how the two interchangeably affect each other. Many Tobagonians and Trinidadians do not see the importance of leaving a will or dying testate, and oftentimes this leaves generational issue as it relates to legal claim of land ownership or title ownership. I am of Tobagonian heritage, being a very proud Daniel and Alfred, and I don't know personally the issues that do arrive with being able to track down family historical claim and title of Tobago land. I am intimately familiar with the challenges that Tobago land title has juxtaposed with old law and RPA title. And so we are coming over to try to empower Tobagonians to help understand land ownership issues and what are some of the solutions available for you in order to obtain proper title to the land that you may be occupying, because there's difference between land occupation and land ownership.
Let's go to, right, so I'm glad that you zero in on the Tobago's situation
Yeah.
as far as it comes to land. They say no proper title. That's how we label to most of Tobago's lands. And really, and in fact, it is not the term, but these people really have title for it. However, the deed may be in grandfather Paul, who died 100 years, and
Right.
his siblings or his next generation, grandchildren and so on, occupy the land. Everybody have a house spot, and they live there for all their lives. But to separate or to get deed to each member of the family is the real challenge. So the owner
Correct.
of the land is because the deed is in his name, but he's no longer existing. The challenge is to get each of these relatives the spot that they occupy. It may not even be a lot or a plot, it's just a house spot. However,
Right.
they don't have paper for it, but they live on grandfather land. Let's speak to how the difference between ownership and occupant. And you can't say that they don't own it because they live on grandfather land.
Right. So legally speaking, we can say that they do not own it. In fact, the marketability of the title is measured by how can you even use the occupation you have. So occupation is occupation, it's physical occupation. But when it comes to land, the marketability or value of land is measured by how much you can use that. So can I carry my occupation to the bank and ask that that occupational rights be mortgaged in exchange for a loan? And the answer is no. The bank needs to get paper title. So what you described is a very familiar and prevalent issue in Tobago and Trinidad as well. But locally, many persons do not assent title from the estate of a deceased person onto the children and or all successors in title. So what you explained there is after the probate process, and this is also, so there's probate, which is right in the will, probate in the will, etc. But many people stop at the grant level and they do not do a deed of assent, transferring title into successors in title. And when these successors in title obtain title, then only then can they thereafter deal with their undivided shares, whether it be undivided third shares, quarter shares, half shares, 17 shares, depending on the amount of children. When they each have their shares belonging to their estates, and then they can give to their children and so on and so forth. There are also options to utilize chattel deeds, which will also be explained and described at the Land Ownership Convention, because you did mention in your scenario about not necessarily having defined plots, but having a house on it. That is something also very prevalent where persons may build and they do not know how much land they occupy. So part of our staff who will be coming over to Tobago, and it's going to be more than about 10 of us or so, will be our in-house surveyor as well among them, ensuring or explaining the importance of delineating proper boundaries to indicate, well, what portion or plot of grandfather's land am I entitled to and on, and what constitutes or consists of my portion of the inheritance? Because all of us could be on the land, but as you rightly said, in order to properly subdivide and allocate and delineate who is to go where, survey is an intrinsic feature of the entire land ownership situation or process, I should say, right? This is because the title document created thereafter needs to describe the area of ownership that this title document is connected or associated to. There must be boundaries, who is on the east, who is on the west, who's on the north, on the south, what is the size of the road reserve, what is the size of the drain reserve, what is the square feet, etc. And all of these things need to be included and incorporated when we speak of paper title. I mean, I didn't even say proper title. I want us to say paper title. Because you could have proper title, as you would have mentioned before, by virtue of an equitable interest in land. But do you have paper title? Is that proper title demonstrated and illustrated by a registered paper title that is going to be recognized in Trinidad and Tobago and by any financial institution for the purpose of mortgage, sale, or lease?
Right.
Okay, and of course, folks, if you're now joining us, we're having a conversation with Shaquilla Daniel, and she is the managing director and senior partner at D.L. Daniel and Associates Limited. And of course, from what I'm seeing here, you're not only qualified, having studied at the University of the West Indies, but you're also a senior legal and title research consultant for the Tobago House of Assembly. Am I getting that correct?
Yes, the legal department there.
Okay, and thank you for being with us. In terms of the convention, so I understand. So day one is about wills and legacy, and of course,
Right.
day two is about Real Property Act, and day three we're looking at valuations and surveys, and this is all happening at the Victor E. Bruce building. But in terms
Right.
of people may not realize or accept the importance of having a valid will. All right, and I know we talk about paper throughout the conversation thus far, but what are some of the risks? And you can speak to some examples that families can face without having that legal document.
Yes, and so I'm glad you reminded me. So the convention, the first day is free, absolutely free. And this is because we want as many persons to come out and draft their own will. In testacy, about 91%, I don't have the exact data, but about 91% of our population in Trinidad and Tobago die without a will or intestate. And this is very, very troubling and difficult because you have to go through the legislative administration process where there has to be a consideration of who was your legal next of kin and how we could find them, and if they died, how we could evidence that they died, and who was your last widow or widower, your last spouse, and what percentage do you have to get, and how many children you had, how many children of the marriage, how many children outside of the marriage, who have their name on the birth paper. It's a lot that happens when there is no will. And so we're begging you. We know that locally there's a lot of superstition surrounding wills. There's a lot of misconceptions about how it's supposed to be done. Our wills to be registered, our wills to be written in a particular way. Who can do it? What is the features of a will? What makes a will valid? All of these things are going to be discussed thoroughly at the convention. We are inviting you absolutely free for the first day. We will be helping persons to write their own will there and then on the first day as well. All right. And so then we're encouraging you to return on day 2 and 3, where there is a small investment to attend, to sort of finish up what we would have discussed on the first day. Dying intestate is expensive as well because the probate process, in relation to letters of application of letters of administration, is a lot longer and can be costly because it includes so much more. It's almost as hunting down the estate, juxtaposed or compared to when there is an actual will. So we really, really, and as a firm, we are championing the cause of trying to end the scourge of intestacy. And this is for first, everybody over the age of 18 should have a will. Because even if you may not have assets and you think you have nothing to gift, you do not know the manner in which you will die. You may die. And you may die in a manner that entitles you for compensation. But without a will, you have no one to represent your estate legally. You have no executor. And
Just
then you have to, it's a lot. It's a lot.
well, I know it's a lot, but you mentioned something there. So you're saying that, I mean, normally, and I'm assuming, when you're at your more senior age, you would think about wills. But are you saying that even at your younger age, you should
Yes.
put things in place?
Yes, it's a common misconception that wills are only for old people.
Well, I thinking
Wills are for
so.
all people. No, wills are for anyone over the age of 18 because we often think of the gifting power of will, but we do not think about the LPR or the legal personal representative part of the will. All right, and this happened to me. My mother was killed in a car accident along with my aunt, and they both died in a manner that entitled them for compensation, right? One didn't have a will and one had a will. I wouldn't say which was who, right? But it was easier for the to when we had to represent their interest in the accident claim. One already had somebody to represent because that person was tested, whereas the other had to go to court first to get appointed something called administrator ad litem, to bring suit. All right. So young people, this is, we see so many young people die with accidents, with in childbirth and different issues. Wills are very important because it also has that executor role that you can appoint somebody to represent your interests in the event of your untimely death. A will is the only document that speaks from the grave, nothing else. No letter, no commission of affidavits, put something together, word of mouth. Only a will survives death.
What constitutes a legal will? There are some bright family member would want to contest the will based on, and sometimes he interpreted it to mean that this will does not worth the paper it is written on. What constitutes a legal will that could stand the test of any scrutiny? Just walk us through.
Right. So the court is going to look at the validity of the will. What constitutes a valid will? What makes a will valid? And according to law, there are 6 primary things that ensures the validity of the will and that the court should consider it a valid will. One, it must be written. We know in the age of technology, persons can have a video recording of themselves, etc. That there's no provision for that in our laws. So it must be written. The testator, the person publishing the will, must be of age of majority, meaning over the age of 18. It must be dated. It must be signed by the testator or duly executed, meaning either if they cannot sign with their handwriting, that it has a fingerprint with the corresponding jurat explaining that this is their fingerprint and why they could not use a written signature. There must be 2 witnesses. There must be 2 witnesses of the will. None of these witnesses should be the executor. And the will must, yes, and the testator must have sound mind. The testator must be of sound mind at the time of publishing the will. And it is often a good practice, and this is for younger legal professionals and attorneys, that if you recognize that the person at the time of publishing the will is so elderly that it may be reasonable to question their mental competence to make legal decisions, not decisions whether they could eat what food they want to eat today or if they want to go outside. They must have legal mental capacity. It's often good practice to accompany the will with a psychiatric medical report affirming for the legal capacity of the testator at the time of doing the will. So these are just some things that makes a will valid. Written, age of majority, signed or duly executed, dated, 2 witnesses, and testator of sound mind.
Very good. Who is the executor? What role does the executor play? And is this a legal person or is this an ordinary person?
Beautiful question. And you need to come to the convention. We want you there at the convention because of these things. All right, the executor is a very important person. The executor is responsible for the probate of the will or having the will proven before the court. They are also important to manage and protect the estate during the probate process, because the probate process is not one that happens overnight. If it's done by a proper probate attorney, it can take anywhere between 6 months to 18 months in order for the will to be properly proven and for it to be, advertised and declared as the last, to be in fact the last will, right? During that time, the executor's role is to protect the estate, to also collect any monies owed to the estate. The estate may consist of rental properties to be collected, etc. They have to do all of these things, preserve and protect the estate in trust for the benefit of the beneficiaries. Let me say that. The executor's role is to probate the estate and preserve and protect, manage the estate in trust for the benefit of the beneficiaries. They are also responsible for any debts or legal claims brought against the estate. So it's not just the benefit of the estate, it's also the debts or the detriment of the estate. They are the legal personal representative of the estate. Anybody bring the estate in court, you have to be there, etc., stating that you are either the executor in waiting because the will has not yet been probated, or you have a grant of probate and you are the LPR, you are the executor.
One more. In the absence of a will and the relatives has to administrate as to first put, let's say it's 4 plots of land. And no will, daddy just say, boy, you build there, Mary, you build there, and Peter, you build there. and that piece over there is for my first grandson. And all carry out my wishes, please, after death. And that's all he left. However, that does not stand up in court. If that
It
is
can.
recorded, let me just put that in. If that is recorded, that he said that, is that admissible? Is that valid?
But so we just spoke of that. We just spoke and we said the first thing that makes a will valid, it must be written. First thing we said,
Not audio.
it must be written. Must
But
be
you
written.
just said this is modern time, you know. You did say that and you could
I
record.
know, but I also said that our laws right now, the administration of the Wills and Probate Act, that is still enforceable and that is we recognize today requires that it must be written.
Written.
All right.
Right?
Lastly,
The reason for that is that we're also in the age of AI, so it could be somebody looking like
Correct.
somebody,
Amber,
a
for
Correct.
smart
example,
man.
about
Yeah.
moving.
All right. But lastly, before Mr.
Yeah.
Cox take you, the whole question of administration. So the land is there,
Yes,
4 plots, each person occupied. We need to cut it out, as we say, or have the surveyors take that. But it has to be
subdivided or delineated.
It has to be administrated. Well, you have to administrate for it. Let's speak to that. Where does that take you, and how is that sorted out or assisted by your conference later on? Let's speak to that. How
Right.
can that be assisted to get it done quickly?
So the administration of the estate is very important. You must first remember we're saying that daddy, when he dies, his ownership, his invisible title is buried with him, so to speak. Think of it like that. It must be assented, or with Jesus was there's ascension. A deed of assent must come from daddy's grave, and without administering the estate, there is no assent of title, and that is why you need to do it. So you need to go through the process. If daddy had a will, you go through the probate process. If daddy had no will, you go to the application for letters of administration. Letters of administration is not a letter. It is not a letter that you can go by the lawyer for. People are mistaken that daddy died without a will and have to get a letter from a lawyer. That's what they commonly say. That is not what letter of administration mean. It is an application that consists of several things, including a general affidavit of the next of kin, describing, all who were related to the deceased, how the deceased die, where the deceased die, a lot of information, the entire inventory of all the assets that was included in the estate, and letters of administration generally take longer than a grant of probate because before the registrar is to grant this, they need to be very thorough that it was accurately represented and that if the grant is given, there is no reason and cause to set it aside. That the right persons are applying, that if it is siblings applying and they say he never had a child, that there's no child existing out there that can then come and lay claim, etc. And so we're going to talk about all of these things at the convention in more detail, and that is why we are begging for you to come out. Knowledge is power, and when we are trying to empower persons with basic legal education first,
Yes,
just the
indeed.
education, so that you can make informed decisions and that we can desist and discontinue with some prevalent local,
Misconceptions.
legal, yes, that's making life very, very difficult, and it causes a loss of generational wealth. That's the the ultimate problem that we have having when these things continue.
And it mash up families in local parlance, and you hear about countless bacchanal in local parlance as well, with regards to
Yes,
the lack of
cutlass,
knowledge and the
drawing, and
ignorance.
nobody talking to this one, and yes, and then who
Yeah,
get married, and you don't like who they get married to, and daddy say that you were supposed to get nothing because you, oh Lord.
yeah, and a high level of ignorance in the real sense and in our sense as well. But in terms of the convention, so okay, the convention takes place. It starts this Friday. The first day one
Yes,
is free, and we spoke
day
about
one is free from
wills,
9
probate,
a.m. to 3 p.m.
letters of administration and so on. It's from 9 a.m. to 3 p.m. as you said there. But day two, $800, and of course you
Mhm,
can give us more
mhm.
details. But you're specifically speaking on day two to the Real Property Act. For viewers who may not be familiar in simple terms, can you just describe briefly how can
Simple,
someone
briefly.
strengthen their deeds and speak to this Real Property Act?
Right, bringing lands under the RPA is a process that most Tobagonians will have to do because there's no title. It's a form of title registration that is based on occupation, right? So there is provisions for what we term adverse possession. I don't want to get into this, it's a lot, but if you have been in possession of lands undisturbed and consistently for a certain amount of years, you will and can be entitled to make an application for a vesting order and have the court recognize your occupation, make it valid, and issue you a certificate of title. And that is what we mean by bringing lands under the RPA. It is a very important process because it gives an occupant who may not have or grandpa who was living there before. They started as a squatter, right? And acquired equitable interest, and that equitable interest can now be regularized, recognized, and paper title given to you in first generation.
There
And
is
um, and this is a very important process.
there is the RPO, and I'm hearing RPA. Make the distinction
Good.
because real property ordinance for RPO, and RPA
Right.
means what?
The Real Property Act. So the
Act.
Real Property Act has replaced the ordinance. It's more or less the same, but the RPA is the one right now that is subsisting or
Okay,
Okay,
or
all right.
currently
okay,
valid. Yeah.
and that would be speaking to in more, I guess, given you would provide more details in terms of the RPA on day two, all right, and
Yes.
this is $800,
Yes.
and day three, just
Yes,
before we wrap,
which
what
is
happens on
less
day three?
than a consultation. Let me just mention that the cost of that is less than a consultation at our firm for a whole hour. And so you're getting less than that for an entire day to come out and be able to not just listen to the convention, but also interact.
Right.
Bring your documentations, have it reviewed. We're going to have surveyors, valuators, legal professionals.
Very
All
good.
right.
All right. Quickly, how do you apply for Real Property Act? What do you do? Do you say 40 acres of land owned by John Paul, who did 100 years, my grandfather, and so I come in to apply? How does it work? How do you apply for Real Property
No,
Act?
it's actually a court application, right? It requires primarily a statutory declaration that is then supported by a number of documents, among them, most importantly, a survey, right? By a licensed surveyor and all the different things that he would know that he needs to accompany his document by. And there's a very comprehensive statutory declaration with other witness statements, etc. It's an application that must be prepared by an attorney at law and must go before a judge, the court, where it has the opportunity to be defended by any other paper title claim, or any other claim owner, and then it is considered, and then a court order is given to for you to vest the property.
And
So
it
it
must
is actually a court
and
procedure.
it must be gazetted as well.
Correct.
Very good. You see, I know something. So I come into the seminar.
Yeah.
So Friday, now Friday. What time again? Just remind us.
Come
Free.
and teach us, man. Come and teach us. So we're starting at 9 a.m. on all of the days, right? International time, not
Tobago time.
local 9 o'clock, right? International time. We are people to time, right? Treat it as any other serious legal event. And so it is going to be from 9 a.m. promptly ending at 3 p.m. because we are going to be there for 3 consecutive days. And so we really want to be timely as much as possible. And so you must register to attend, even though it is free. You cannot just walk in Victor E. Bruce building and say, I came for the convention. You must register in advance because we need to know how many people that we are catering for essentially.
And
Yeah.
share how exactly you can register. And also, you are getting the opportunity to get one-on-one consultations. Just confirm that, if that's true.
Not on day one, because that is going to be a very much a bigger day. We are going to make provision for it on day 2 and 3, certainly. And but you will have on day one a live question and answer session that you could ask your questions and have them answered, and we're going to discuss with you. And to register, you go on any of our pages. You look for DL Daniel I think it's DL Daniel on Instagram, on Facebook, on TikTok. Look at our website, dldaniel.com, and you just click on one of the links there, and you will see the Tobago Land Convention right there, right? You look for us on any social media platform, and you can find it. You can find us on Facebook primarily. A lot of persons can go to Facebook. There's the Land Ownership Convention, the QR code on the flyer itself for you to register. Or if you do
Excellent.
not want, you cannot get one, you don't understand what's going on, just call us. Call our numbers from between 9 a.m. and 5 p.m. The office lines is 241-3772, 241-3772, or 741-3084. 741-3084. Call the office and have someone manually assist you with registration. If you don't want to go through all that technology thing, call the office 241-3772, 241-3772, or 741-3084, 741-3084. From 9 a.m. they're going to open. All
Okay.
right, 9 a.m. and
All right.
have them
Jumaane,
register for you.
thank you very much. Jumaane. Thank you for being with us this morning, and so much
Thank you for
information
having me.
disseminated. And we expect on Friday, people will be up front and personal as to get the information directly. Thank you, ma'am, and all the best to you.
Same to you. Have a good morning.